Welcome back guys to our channel. So this is the business law series. So nasa second part na po tayo ng nature and effects of obligations. Don't forget to subscribe to be updated on the release of upcoming videos. Also, don't forget to hit the like button if you like this video. So last time dinivide natin yung mga contents natin dito sa chapter 2 into 2 parts. Pero kung mapapansin nyo, nadagdagan po yung second part natin. Pero medyo maliit lang naman na maliit lang naman na topic itong transmissibility of rights. Okay? So bali isang isang article lang yan. Okay? So before anything else, nais ko po lamang balikan yung kung saan tayo nagtapos. Kung mapapansin nyo, nagtapos po tayo sa different types of breaches. So yan yung 4. Okay? Pero this time, i-detalye po natin sila. So ito po yung related article or related provision. So Article 1170, those who in the performance of their obligations are guilty of fraud, negligence, or delay, and those who in any manner contravene the tenor thereof, liable for damages. Okay? So let's start by comparing fraud and negligence. So we created a table that compare fraud or dolo and negligence or culpa. So the first comparison na titignan natin is with regards to intent. So number 1, sa fraud, there is a deliberate intent to cause damage or injury to another, while in negligence, wala pong deliberate intent na ganun. So there is only a lack or insufficiency of diligence required in a given situation. So kung i-recall natin yung diligence, kapag silent si problem, okay, the specific situation will require for you to observe the diligence of a good father of a family. So that is also called ordinary negligence. Okay? Pero depende yan sa situation. May mga certain situations wherein it requires you a certain level of diligence higher than diligence of a good father of a family. Okay? So such as in a contract of carriage, so you must exercise extraordinary diligence. So next, in fraud, the liability cannot be mitigated. So when we say mitigated, mababawasan or malilesen in English. Okay? So ang fraud, it cannot be mitigated by the court, while negligence, depending on the circumstances, can be mitigated by the court or pwedeng bawasan ng korte. Okay? Lastly, okay, we have the waiver of an action for future fraud is void. While in negligence, there are certain instances that waiver of an action for future negligence may be valid. So, sa fraud, absolutely void po ang waiver of action. So, when we say waiver of action, yun yung kumbaga, isa-set aside mo yung right mo para kasuhan ang isang tao dahil may fraud siyang ginawa. So, for example, sa isang kontrata, isa sa provision ng isang kontrata ay in case na may mangyaring fraud in the future, bawal mo akong kasuhan. So, yung ganong klaseng provision or ganong klaseng stipulation ay bawal po. Hindi po pwedeng gumawa ng ganong klaseng stipulation or provision sa isang contract. Dahil ang tawag po doon ay waiver of an action for future fraud. Okay? Pero pagdating naman sa negligence, so pwede pong stipulate yun or gawing provision. So, depending on the circumstances po yun. Okay? So, pero with regards to past fraud, dahil ang binanggit lang naman dito ay future fraud, with regards to past fraud, so pwede po siyang i-waive. So, for example, gagawa kayo ng panibagong contract wherein papatawarin mo na daw yung nakakontrata mo na tao na hindi mo na siya kumbaga kakasuhan sa korte dahil sa nagawa niyang past fraud. So, pwede po yun. Okay, in that case. Okay, ang bawal lang talaga is yung waiver of an action for future fraud or fraud na gagawin pa lang. Okay? So, next. So, may mga instances naman wherein fraud or wherein negligence is equivalent to fraud. So, when is negligence equivalent to fraud? So, when there is gross negligence. So, what do we mean by gross negligence? So, this is the carelessness which in reckless disregard for the safety or lives of others and is so great it appears to be a conscious violation of other people's right to safety. It is more than simple inadvertence, but it is just shy of being intentionally evil. So, ang source po natin dito ay dictionary.law.com. So, in short, pag sinabi natin gross negligence, so, kung ang simpleng negligence lang, may kulang, kumbaga, kinulang ka sa diligence na ina-exert mo in a given situation, when we say gross negligence naman, kumbaga, almost totally wala. Okay? Almost totally wala kang diligence na in-exert, okay, in a given situation. So, kuminsan, nagiging equivalent to fraud na yon. So, depende yun sa situation. Okay? So, inuulit ko, ang gross negligence, almost none or totally wala. While yung ordinaryong negligence lang is you lack, okay? There's a lack of diligence. Okay. There's a lack of diligence dun sa required diligence. Okay? So, for example, extraordinary diligence pero ang in-exert mo lang ay ordinary diligence. So, you lack diligence. So, mayroong negligence doon. Pero, what if ultimo ordinary negligence, wala kang in-exert? So, siguro pwede siyang maging gross negligence in that case. Okay? So, next. So, we have an illustrative case, negligence. So, let me read first. Yami is the driver of a carefully driven bus owned by the Black Bulls Incorporated. While traversing a highway, Yami didn't notice Asta, a pedestrian, while crossing a pedestrian lane. Since the bus speed is not fast, Asta suffered serious but not fatal injuries. So, in short, hindi siya namatay. A passenger of the bus likewise suffered serious but not fatal injuries. So, what action or actions can Asta and Yuno take against Yami and or Black Bulls Incorporated? So, next slide, we'll have a table that shows, okay, the different types of negligence, which are culpa aquiliana, culpa contractual, and culpa criminal. So, in our last video, we mentioned those three, but not in details, okay? So, in here, may mga certain factors tayo na i-consider. So, una is yung object or the source of liability. So, sa culpa aquiliana, the source of the liability is the negligence itself. Okay? So, meaning, our source of obligation in here is quasi-delic. Second, culpa contractual, the source of the liability is the breach of contract due to negligence. Okay? So, in here, the source of obligation is contract. Okay? So, contract po yan. And lastly, the source of liability in culpa criminal is the criminal negligence. Okay? So, in here, the source of obligation will be delic. Okay? Next, we have the evidence. So, in order to prove, okay, or in order to assert the action, for example, you take an action for culpa aquiliana, so ang needed evidence ay the following. So, under culpa aquiliana, there must be preponderance of evidence as well as culpa contractual. So, when we say preponderance of evidence, so the more evidence you have with regards to the matter, so the the more likely na you will win the case. However, in culpa criminal, there must be proof beyond reasonable doubt. So, compared to preponderance of evidence, proof beyond reasonable doubt, kumbaga tumitingin siya sa quality ng evidence that will really point out that the person is guilty of what he parang kumbaga of what action yung ginawa niya or anong crime ba yung ginawa niya. Okay? So, kailangan dyan proof beyond reasonable doubt. So, yun lang kumbaga dalawa lang ang evidence na kailangan dito. So, in culpa achilliana, both in culpa achilliana and culpa contractual, parehas lang. Pero pagdating sa culpa criminal, so we need proof beyond reasonable doubt. So, next, existence of pre-existing contract required. So sa culpa achilliana, so no. Ang kailangan lang actually ng existence of contract is yung culpa contractual. So hindi mo naman kumbaga hindi mo pwedeng ikaso yung culpa contractual kung wala talagang nag-exist na contract between you two. Okay? So in the second in the fourth factor, so who may take action. So sa culpa achilliana, it may be either Asta or Yuno. So if we recall dun sa situation, si Asta yung pedestrian while Yuno is the passenger. So sa culpa achilliana, ang pinuprove po natin dyan ay there is negligence. Okay? There is negligence. Okay, on the part of the driver. So, kumbaga, si Asta and Yuno, sila yung entitled with regards to kung pwede ba nilang ikaso yung culpa achilliana. Pagdating naman sa culpa contractual, si Yuno only. Why? Because si Yuno lang ang merong contractual relation dun sa bus company. So, siya kasi yung passenger. So, with regards to Asta kasi, pedestrian lang siya. So, limited lang siya dun sa culpa achilliana wherein the source of the liability or yung negligence niya lang. Hindi pwedeng maging culpa contractual yun dahil in the first place, wala naman silang contractual relation. Pagdating naman sa culpa criminal, just like the culpa achilliana, si Asta and Yuno ang pwedeng mag-take action. So, next. Action taken against. So, in culpa achilliana, so pwede mong kasuhan is either Yami, the driver, or the Black Bulls Incorporated, which is the owner of the bus driven by Yami, or both of them can be prosecuted. Okay, pagdating naman sa culpa criminal, so it's only Yami. Okay, it's only Yami. Okay, siya lang kasi yung kumbaga if ever merong if ever merong criminal intent dyan or makakasuhan siya criminally or criminally prosecuted, si Yami lang yung pwede dahil kumbaga siya lang naman yung directly involved, unless syempre may kinalaman dyan si Black Boots, pero medyo malayong mangyari yon dahil accident, kumbaga parang accident lang naman itong nangyari ito. With regards to culpa contractual naman, si Black Bulls Incorporated lang yung makakasuhan dito. So, bakit? Kasi, actually, the contract existed not between Yuno and Yami. Because Yami is only the driver of the bus. But the contract existed between Black Bulls Incorporated and the passenger Yuno. Okay? So, therefore, sa culpa contractual, ang kinakasuhan mo dyan is yung bus company mismo. Okay? Next, with regards naman to the defense of Black Bulls Incorporated, so under culpa contractual, pwedeng matakasan ng Black Bulls Incorporated yung kanyang liability by showing proof that it exercised diligence in the selection and supervision of the of its employees, specifically the driver. Okay? Pagdating naman pero sa culpa contractual, hindi pwedeng maging defense po yun. At lalo nga na pagdating sa culpa criminal, hindi rin pwedeng maging defense yun. Pero in the first place kasi sa culpa criminal, hindi naman siya yung kinakasuhan pagdating sa culpa criminal. Si Yami po yung kinakasuhan. So, in terms of defense, hindi niya naman talaga kakailanganin yun. Okay? Pero with regards to liability, so may mababasa tayo dito. So, hindi porket hindi siya yung kinakasuhan under culpa criminal, wala na siya totally liability. So, sabi dito, Black Bulls Incorporated is subsidiary liable if Yami cannot pay damages. So, when we say damages in here, we refer to the civil damages or civil liabilities. Okay? So, usually, yung mga drivers naman kasi, medyo mahirap lang sila. So, may tendency na hindi talaga nila mapabayaran yung civil damages na igagrant ng court dun sa dalawang victims natin in this case. So, there is no defense available since Yami's negligence is conclusive evidence for purposes of subsidiary liability on the part of Black Bulls Incorporated. Okay? So, yan po. So, tignan nyo mabuti yung table. Post nyo kung kailangan nyo pang kailangan nyo pang i-absorb. Okay? So, next slide. So, next naman, punta na tayo sa delay. So, this time, magiging thorough ulit tayo. So, actually, there are two types. Okay? May dalawa ang mababanggit na types ng obligation dito. So, we have unilateral obligations and reciprocal obligations. So, when we say unilateral obligations, only one of the party is liable. Okay? However, in reciprocal obligations, actually this is reciprocal obligations is a type of what do you call this? The bilateral obligation. So when we say bilateral obligation kasi, both parties are liable to each other. So under bilateral, I mean, there are two types. So we have reciprocal obligations and non-reciprocal obligations. So reciprocal obligations actually are obligations wherein there is no kumbaga nabanggit, okay? There's no specific time or period when the obligations or the corresponding respective obligations of the two parties will be made. Okay, so we have here general rules, okay, and the exemptions with regards to delay. So under unilateral obligation, we have no demand or delay. So kung walang demand, hindi mag-i-incur ng delay si debtor. Okay? So however, there are exemptions. So number 1, the law or obligations to declare. Number 2, time is the controlling motive for the establishment obligation. 3, demand would be useless. Pagdating naman sa reciprocal obligation, delay occurs from the moment one party fulfills its undertaking while the other does not comply or is not ready to comply in a proper manner with what is incumbent upon him. And the exemption is if there will be stipulated dates for the performance of respective obligations. Okay? So, let's get on with the examples. So, unahin muna natin ang unilateral obligation. So, delay, illustrative problem. So, row 1 promised to give his dog named Ben to Alan to be delivered on September 15, 2020. Okay. So, let's analyze the situation. So, general rule, no demand, no delay. So, first analysis, okay, suppose on September 15, 2020, Alan did not demand the delivery of the dog and row 1 did not deliver the dog until September 16. So, in this first scenario, tanong, meron bang delay dito na na-incur si row 1? Okay? So, the answer is, there's no delay. Okay? Row 1 is not yet in delay. Why? Because Alan did not yet demand or did not demand the delivery of the dog on September 15, which is supposedly the date kung kailan i-deliver dapat ni row 1. So next situation, suppose on September 15, 2020, Alan demanded the delivery of the dog and row 1 did not deliver the dog until September 16. So in this case, dahil nag-demand si Alan noong September 15, dapat i-deliver niya noong September 15. So in this case, row 1 is in delay. Okay, so ganun lang po kasimple yun. Okay, punta naman tayo sa mga different exemptions under the unilateral obligations. So when the obligation or the law expressly so declares, so suppose row 1 and Alan agreed that Alan doesn't need to make demand for row 1 to incur delay on September 15, 2020. Okay, so this is when the obligation so provides. So ibig sabihin, doon pa lang kumbaga doon sa usapan nila, hindi na kailangan mag-demand daw ni Alan in order for row 1 to incur delay. So, meaning, yun nga, hindi mag-a-apply yung general rule natin which is no demand, no delay. Another example, so payment of taxes. So, law so provides. So, in this case, hindi kailangan, for example, hindi kailangan ng mag-demand ng BIR all the time para bayaran mo na yung taxes due mo on certain dates. Okay? So, isa po yung exemption. Okay? So, next, time is the controlling motive for the establishment of obligation. So, for example, suppose Ben or the dog is a talented dog and row 1 oblige himself to deliver Ben to Alan to perform in Alan's birthday party on September 15, 2020. In this case, the time, which is September 15, 2020, is the controlling motive why the obligation to deliver the dog was established. Okay, so there's no point in delivering the dog beyond September 15, 2020 because the main reason why the dog will be delivered to Alan is because the dog will perform in his birthday. So, in this case, the time is the controlling motive why the obligation to deliver the dog was established in the first place. Okay? So next, demand would be useless. So suppose Ben died because of the negligence of row 1. So before September 15, 2020 arrive, Ben died, let's say, dahil hindi niya pinakain ng 10 araw, namatay si Ben. So that will be associated with the negligence of row 1. So, in this case, for example, dumating ang September 15, hindi nakapag-demand, assuming hindi alam ni Alan na namatay yung aso. So, pagdating ng September 15, hindi siya nakapag-demand. Okay, although hindi siya nakapag-demand, okay, dahil imposible naman na ma-deliver niya pa ito noong December 15 dahil patay na nga yung aso. So, it is still considered that row 1 is in delay even though Alan did not demand the delivery of the said dog on September 15. Okay? So, ayan. Yun po yung illustration natin with regards to unilateral obligations. So, punta naman tayo sa reciprocal obligations. Okay, so hindi po natin napalitan. So, this is supposedly reciprocal. Okay. Reciprocal obligations. So, Adam sold his only car to Byron for 150,000 pesos. So, there was no agreement regarding the time of delivery and the time of payment. So, next is our analysis. So, ayan. So, general rule, when one party fulfills its obligation, delay on the other starts. Okay, so analysis. Suppose Byron paid 150,000 the following day. So Adam must deliver the car immediately after receiving the payment on the same day to avoid incurring delay. Dahil kung hindi, mag-incur na siya ng delay. Okay? Ganon din sa kabila. Suppose Adam delivered the car the following day, Byron must pay the 150,000 the same day to avoid incurring delay. So, ganun po ang rule when it comes to what do you call this? Reciprocal obligations. So, balikan natin. So, syempre, ang exemption nito is when there is stipulated time kung kailan nila i-perform yung respective obligations nila. So, in this case kasi walang stipulated time. So, from the time kung kailan finulfill nung kabila, kailangan mo na rin i-fulfill kaagad. Okay? So, unless magkaroon kayo ng further agreement na ganito na lang ako magbabayad, etc. Okay? So, next topic, so we have fortuitous event. So, what is fortuitous event? So, in order for fortuitous event or casus fortuito to exist, these are the following requisites. So, number 1, the cause of the breach is independent of the debtor's will. So, meaning, hindi po siya kontrolado ng debtor. Yung, kumbaga, yung occurrence niya ay, kumbaga, hindi po kontrolado ng debtor, yung occurrence ng mismong event na yun. So, second, the event is unforeseeable or unavoidable. So, if it's unforeseeable, so for example, lightning, so kapag biglang may tumamang kidlat, syempre hindi mo mafu-foresee yun. Okay? At syempre, although mafu-foresee mo, let's say malakas ang ulan, tapos kidlat ng kidlat, although parang nararamdaman mo na may darating na kidlat, pero kahit na feeling mo may darating na kidlat, hindi mo naman ma-avoid actually. Okay? So, events that are unforeseeable or unavoidable are one of the requisites of fortuitous event. So, number 3, the event is such as to render it impossible for the debtor to fulfill his obligation in a normal manner. We'll have an example for this later on. So, pag sinabi natin impossible kasi, for example, namatay yung aso, specific dog, by being struck by a lightning, so, hindi mo na ma-deliver yung dog alive, syempre. Number 4, the debtor did not take part in causing the injury to the creditor. So, aside from natural occurrences such as lightning, such as mga natural disasters such as typhoon, earthquakes, etc., pwede rin kasi maging makonsider as fortuitous event yung mga actions made by man, such as armed robbery. Okay, so, yung number 4, so, dapat, si debtor mismo, hindi siya kasama dun sa armed robbery. Baka naman kasi, kasabwat niya yung, for example, nanakawan siya before, let's say, delivering a specific thing, okay, to the creditor. So, let's say, nanakawan siya, okay, through armed robbery. Anong nangyari dito? So, kung kasabwat, si debtor din lang pala para, kunwaring extinguish yung kanyang obligation, kung kasabwat siya, hindi pa rin yung ma-extinguish, okay? So, dapat, the debtor did not take part in causing the injury to the creditor. Okay. So, ayan, general rule, no one shall be liable for fortuitous event. So, there are certain exemptions pero the law or stipulation expressly so declare. Number 2, the nature of the obligation requires the assumptions of risk. Number 3, obligation is other than obligation to give a specific thing. And number 4, debtor is already in delay. So, let's illustrate those following. Okay, so, so illustrative case muna to with regards to the fortuitous event itself. Okay, Soma bound himself to give Megumi a specific kitchen knife on December 31, 2020. While on his way to deliver the knife, he was robbed by a group of armed men. There was nothing he could do. So, okay. So, balik muna natin. So, in this case, Soma's obligation to deliver a specific knife to Megumi will be extinguished. Why? Because the specific thing was lost through a fortuitous event. So the event wherein nanakawan siya by armed men is syempre unforeseen siya. Syempre ayaw rin naman ni Soma na manakawan siya. At the same time, let's assume in this case na hindi niya kasabwat yung mga armed men na yan. Okay, so in that case, ma-consider natin this case as a fortuitous event. So therefore, Soma's obligation will be extinguished or wala na. Okay? So what are the exemptions, by the way? So number 1, the law or stipulation expressly so declare. So in this case, sa number 1, there are certain cases wherein kahit na merong fortuitous event, may liability pa rin si debtor. So for example, a possessor in bad faith shall be liable for deterioration or loss in every case, even if caused by a fortuitous event. So for example, Ano ba yung mga examples ng possession in bad faith? So for example, may ninakaw, yung isang magnanakaw. So ninakaw niya yung isang bagay, okay, while it's in his possession. So in bad faith siya. Okay, so possessor siya in bad faith. So ayan, possessor in bad faith siya. And let's say yung specific thing na yon ay nawala through a fortuitous event. So let's say biglang bumagyo or biglang nagkalindol tapos nawala yung bagay na yon, or biglang nagkasunog. Okay, so ang mangyayari is magiging liable pa rin siya. Okay, what is his liability? Syempre, ibalik yung bagay na yon. Kung hindi niya na ibalik kasi nawala nga via fortuitous event, syempre babayaran niya yung value of the thing nung bagay na yun. So there will be reparation, and he will also be criminally prosecuted. So in that case, kahit na ang cause ng pagkawala ng specific na bagay na yun, kahit fortuitous event pa yan, magiging liable pa rin siya. Okay, so that is true in the following cases then sa the Bailey Incommodatum. So, commodatum, by the way, is kapag humiram ka ng bagay. So, pag may pinahiram sa'yo at nawala ito, kahit na fault mo pa yan or hindi, kumbaga, magiging liable ka pa rin. So, let's say, pinahiram ka ng kaibigan mo ng, let's say, laptop. So, kahit ang naging cause pa niyan ay fortuitous event or fault mo, magiging liable ka pa rin. Okay? So, ayan. Pero certain instances lang. May mga certain instances na banggit dito. Hindi naman lahat ng instances. So, kung gusto nyo makita yung mga certain instances na yun, punta kayo sa Article 1942. Okay? Okay. So, the officious manager in negotiorum gestio shall be liable for any fortuitous event in certain instances. So, for example, yun nga, na-meet lahat ng requisites ng negotiorum gestio. So, ikaw, for example, na kapitbahay ay voluntarily takes charge of the house of your kapitbahay na yun nga, okay, pero ang nangyayari, instead of ma-develop or mapaganda yung bahay or whatsoever na ginagawa mo doon para i-maintain yun, is mas nakasira ka pa. Okay, so whether that yung pagkasira ng bagay na yun or any part of the house ay due to your fault or due to fortuitous event, it doesn't matter. You will still be liable in certain instances ulit. In certain instances. So, yung mga certain instances na yun, hindi na natin nilista dito dahil medyo marami-rami sila. So, kung gusto nyo makita, punta kayo sa Article 2147. Okay? So, next. So, by the way, these are, when the law expressly so declare. Okay, pero kailan naman if the stipulation expressly so declare. So, kapag daw pag-usapan mismo sa contract na kahit, for example, doon sa contract nyo, may provision doon wherein kahit fortuitous event pa daw yung naging cause ng loss ng isang thing is magiging liable pa rin. So, that will be an exemption. Okay, to the general rule wherein no one shall be liable for fortuitous event. So, next exemption, so nature of the obligations requires the assumption of risk. Okay, so best example is yung mga insurance contracts natin. So yun nga, let's say fire insurance, okay, specifically fire insurance sa isang building. So sabihin natin yung naging cause ng fire ay through a fortuitous event. So magiging liable pa rin syempre si insurance company dahil yun yung yun yung trabaho nila. Kumbaga yun talaga yun eh. It requires the assumption of risk. So in this case, hindi mag-a-apply yung general rule natin wherein no one shall be liable for the no one shall be liable in case of fortuitous events. Okay. So next, obligation is other than obligation to give a specific thing. So in here, so for example, obligation to give a generic thing. So if ever nawala man yung isang bagay na yun, supposedly magbabayad ka ng pera. So money is considered a generic thing. So pag magbabayad ka ng pera, tapos let's say nanakaw yung perang yun, hindi may extinguish yung obligation mo dahil ang pera ay isang generic thing. Okay? So, yun ang mangyayari doon. Pwede mo namang pambayad ang other ibang pera. Okay? Pero kapag specific thing kasi, hindi ka pwedeng mag-deliver ng other thing kasi yung specific thing na yun yung napag-usapan nyo na kailangan i-deliver or obliged na i-deliver si debtor. Okay, so what's this? So, exemptions. Okay, so nadoble natin. Okay, so ayan. Debtor is already in delay. So, let's take, for example, yung dating example natin sa delay. So, row 1 promised to give his dog named Ben to Alan to be delivered on September 15, 2020. So, suppose row 1 did not deliver the dog on September 15 when Alan demanded it. In this case, row 1 incurs delay. Okay? Okay. So, si row 1, in delay na siya officially. So, when row 1 decides to deliver the dog on September 16, but before he reached Alan's house, the dog was struck by lightning and immediately killed it on the spot. Although yung naging reason for the loss of the dog is a fortuitous event, hindi na po mag-a-apply yung general rule natin, which is no one shall be liable for fortuitous event, which effectively will supposedly extinguish row 1's obligation. Pero in this case, hindi po may extinguish yung kanyang obligation. Bakit? Kasi he already incurred delay. Okay? So, next part, we have damages. So, we have damages. So, these are the 6 types of damages under the Civil Code. So, we have actual or compensatory damages, moral, nominate, temperate or moderate, exemplary or corrective, and lastly, the liquidated damages. So, among these 6 types of damages, only the actual or compensatory damages needs proof of pecuniary loss. So, when we say pecuniary loss, this is loss in terms of money, okay, monetary amount or monetary value. So, there's a need for proof of loss talaga. So, kung wala kang maipakitang proof, hindi ka pwedeng hindi ko pwedeng awardan naturally ng court ng tinatawag nating actual or compensatory damages. Pero may mga other options ka pa. So, yung 2 to 6, okay, itong 5 to, hindi naman nila kailangan ng proof of pecuniary loss. So, ito yung mga pwede mong ma-claim or pwedeng i-award sa'yo ng court in case na wala kang proof of pecuniary loss. Okay? So, ayan, punta tayo sa detalye ng mga different damages na ito. So, number 1, for actual or compensatory damages. So, kung natandaan nyo, ito lang ang tanging type ng damages wherein kailangan ng tinatawag nating proof of pecuniary loss. So, in this case kasi, for example, sa mga copyright infringement cases, usually, para mag-grant ang korte ng actual or compensatory damages dun sa dun sa plaintiff is usually kailangan nila ng tinatawag nating proof of pecuniary loss. So, for example, sa copyright infringement is nawalan daw sila ng sales due to copyright infringement ng let's say isang small business. Okay? So, ang mangyayari doon is kailangan nilang mapatunayan na dahil nga dun sa copyright infringement na ginawa ng is nagkaroon sila ng tinatawag nating lost sales. So, yung lost sales na yun, kailangan nila ng proof na bumaba nga talaga yung sales nila. Okay? So, kung napatunayan nila yun, mag-grant yung court ng tinatawag nating actual or compensatory damages. So, to read more about actual or compensatory damages, pwede kayong mag-start sa Article 2199 ng Civil Code. Okay? So, next naman, we have moral damages. So, under moral damages, dyan nagpo-fall yung mga physical suffering, fright, serious anxiety, and other than that, nandyan din yung mga, let's say, mga tawag dito, kunwari, napahiya ka, so, tandaan nyo rin yung physical suffering, most commonly, malito ng mga estudyante, akala nila yung physical suffering, nagpo-fall siya sa, let's say, actual daw, okay, pero actually, physical suffering, for example, na-aksidente ka, so let's say gas-gas lang, so syempre wala kang wala kang, kumbaga, walang perang mawawala sa'yo, hindi ka magpapa-hospital. Pero, pwede ka pa rin mag-claim ng tinatawag nating moral damages. Okay? So, aside from the physical injuries you suffered, you will also, you can also claim moral damages due to, yung kumbaga, shock or na-trauma ka na, for example, dahil sa event na yun. Or, di ba, yun nga, medyo naging negligent yung driver doon. So, dahil doon, lagi ka nang tumitingin sa kalsada, sa left and right. So, nagkakaroon ka na ng, let's say, anxiety, serious anxiety. Okay, so, ayan. So, to read more about moral damages, you can start sa Article 2217 under the Civil Code. So, number 3 naman, nominate. So, take note yung 2 to 6 natin, hindi po kailangan dito ng proof of pecuniary damages. Or proof of pecuniary loss, I mean. Okay? So, number 3, nominate. Okay, so nominate damages are damages, what do you call this? Granted to the plaintiff in order to vindicate or recognize his right. So, ang tanging kailangan mo lang mapatunayan dito ay meron nga bang nalabag na right mo. So, kung meron man, okay, so nominate damages yun. Kahit na wala kang na-incur na damage or injury due to that, let's say violation ng right mo na yun, kahit walang nangyayari sa'yo, kahit hindi ka napahiya, kahit wala, totally wala, from the fact na na-violate yung right mo, pwede kang mag-claim ng ganitong klaseng damages or pwedeng i-grant sa ito ng court. Okay? So, yun yung nominate damages. Pero in terms of monetary value, usually ito yung pinakamaliit dahil yun nga, simple lang naman patunayan to. Kailangan mo lang patunayan if merong na-violate na right. Merong na-violate na right. Okay? So, number 4, temperate or moderate damages. Okay, so in number 4, may mga certain instances kasi na we are sure that there is a pecuniary loss, but we cannot prove with certainty the amount. Okay, the amount of that certain damages. So, usually si court, nag-grant na lang siya, which is usually lower than actual or compensatory damages but higher than the amount granted in nominal damage, but nominate to. So, nominate, okay, nominal damages. Okay, so nagkamali ba ako ng, okay, so nominal. Okay, so we spell it as nominal. Okay, so to avoid confusion tayo. Okay, so nominal damages. Okay, so nominate damages. So, medyo nagkamali tayo dyan sa part na yan. Okay? Okay, so, moving forward, so, yun nga, ang temperate or moderate damages usually in terms of ginagrant ng court, mas mataas siya normally sa nominal damages, pero mas mababa siya sa usual, actual, or compensatory damages. So, to read more about temperate or moderate damages, so mag-start kayo sa Article 2224. Okay, so number 5, exemplary or corrective damages. So, usually imposed to set an example for the public good. So, mag-start siya sa Article 2229. So, for example, usually, very common ito when it comes to yung mga mga criminal cases. For example, nagnakaw or nagpumatay or nang rape or whatsoever. So, usually, may tinatawag tayong exemplary or corrective damages in order para ginagrant siya para ang mangyari is hindi na gayahin ng iba. Okay? Parang ganoon. Okay? So, exemplary or corrective damages. So, lastly, liquidated damages. So, these are damages agreed upon by parties to a contract. So, usually, these are predetermined damages. So, for example, sa isang kontrata, sa isang contract of loan, if ever daw hindi ka nakapagbayad for, let's say, 2 months, 3 months, parang ganun, or depende sa magpag-uusapan, magkakaroon ka ng tinatawag nating penalty. So, that is a type of liquidated damages. Okay? So these are damages predetermined beforehand. Okay? So yun yung mga different types of damages po natin. Okay? So ayan. So now let's go to presumptions. Okay? So what are presumptions? A rule of law which permits a court to assume a fact is true until such time as there is a preponderance, okay, of evidence which disproves or outweighs the presumption. So this is the definition, source from dictionary.law.com. So there are actually two kinds of presumptions. We have conclusive presumptions. These are presumptions that cannot be rebutted by additional evidence or argument. Second type is the disputable presumptions. This can be rebutted by additional evidence or argument. So, to read the examples of conclusive presumptions, you may search Rules of Court, Rule 131, Section 2. So, may mga sinulat siya dyan or nakalagay dyan na mga examples ng conclusive presumptions. Okay? Pero, hindi yan yung kumbaga, hindi lang yun. Kung ano yan yung nakasulat dyan, hindi lang yun yung lahat ng conclusive presumption, as well as yung nandito sa disputable presumption. Kung anong nakasulat dito sa Rules of Court, Rule 131, Section 3, hindi lang yan lahat ng disputable presumptions po natin. May mga iba pa. Okay? Pero we will not focus on the examples of this, kundi we will focus on the provision under the current chapter or current, di ba? Dito sa obligations contract. So, we have two disputable presumptions actually. So, number one, okay, so we will focus on the disputable presumptions under our current scope or coverage, which is nature and effects of obligations. So, we have two disputable presumptions, namely number 1 and number 2. Nakasulat po siya dito. So number 1 is the receipt of principal by the debtor without reservation with respect to the interest shall give rise to the presumption that said interest has been paid. So kapag every time na nagbabayad tayo at nabayaran na natin si principal obligation, there is a presumption na pati yung interest na bayaran na din. Okay, unless it will be disputed by other facts or evidence. Okay. So, dito, kaya nga kapag, kung maalala nyo, kapag nag-solve kayo ng mga, let's say, mga bonds or mga notes, parang, tawag dito, yung mga non-interest bearing notes. So, every time na merong payment, it will first be applied to interest. And, syempre, yung residual, ma-apply siya sa principal. Okay. So, therefore, dahil nga ganun yung usual practice, so, there is a presumption na kapag nabayaran yung principal, nabayaran na rin yung interest. Dahil, syempre, bago mo mabayaran si principal ay inuuna mo munang bayaran si interest. Okay? So, dyan nanggaling yun basically. Okay? So, next presumption is the receipt of latter installment of a debt without reservation as to the prior installments shall likewise raise the presumption that such installments have been paid. Okay? So, kapag nabayaran si let's say, second installment, third installment, so there is a presumption na nabayaran na rin yung first installment. Okay? Without reservation to prior installments kasi. Okay? So, pero, syempre, rebuttable yun or disputable yun. So, meaning, kapag pakita ka ng evidence na hindi pa siya nagbabayad ng first installment, so ayan, hindi, kumaga, marirebat yung specific presumption na yun. Okay? Pero, this type of presumptions are not available. For example, itong number 2, yung pag naka-receive ka ng latter installment, this presumption is not available when we are paying taxes. So, for example, we paid our tax on 2019. So, if we paid our tax on 2019, it doesn't mean that we already paid our taxes way back 2018, 2017, etc. So, there's no such presumption. Okay? Okay, unlike in debts, okay? So, such as number 2. Okay? So, paki-take note na lang yun dahil in my experience as a teacher, madalas lumalabas yun sa exams or quizzes. Okay? Okay. Last but not the least, yung topic with regards to transmissibility of rights. Okay? So, pag sinabi natin transmissibility, so we refer to the ability of certain rights to be transferred from one person to another. So, general rule, all rights acquired in virtue of obligations are transmissible or transferable. So, these are the exemptions. So, number 1, exempted by law. So, the right to vote during elections is exempted by law. So, hindi po pwedeng pwedeng i-transfer yung right mo para bumoto during elections. Number 2 naman, exempted by stipulation. So, for example, naka-receive ka ng scholarship. However, the provision of the scholarship is that, kumbaga, ikaw lang pwedeng makaklaim nun. Hindi mo pwedeng i-transfer yun sa iba. So, it is exempted therefore by stipulation. And lastly, not transmissible, okay, by the very nature of the obligation, by the very nature of the right. So, for example, your right to attend your own wedding ceremony. So, by nature, hindi mo pwedeng, hindi ka pwedeng proxyhan to. For example, ikaw yung groom, okay, tatawagin mo yung kaibigan mo bilang maging proxy. So, ikaw ba naman gusto mo, you may kiss the bride, so yung kaibigan mo hahalik dun sa asawa mo, and vice versa, syempre hindi. Okay? So, these are the exemptions to the general rule. So, ulit natin, general rule, all rights are transmissible, however, there are certain exemptions. So, we have 3 listed down here. Okay? So, dito muna nagtatapos ang ating nature and effects and obligation. So, ayan. Okay. So, part 2. So, before anything else, I would like to invite you to sign up on the link below. So, ano bang makukuha nyo doon? So, meron tayong mga pinrepare na questions na pwede nyong sagutan at pwede nyong matest if may natutunan nga ba kayo dito sa ating mga videos, specifically sa chapter 2, which is nature and effects of obligation. So, wag kayong magalala, it's free, okay, free for everybody. So, ayan, you can sign up anytime you like. So, just check the link on the description. Okay, so, also don't forget to subscribe. Okay, we will be very happy every time yung makikita namin may mga subscribers. So, ayan. Pero other than that, syempre, para mas mabilis kayong ma-alert sa mga upcoming uploads namin. So, ayan. Okay, and also, don't forget to like the video if you like the video. Okay? So, pero kung may mga comments and suggestions kayo, so, huwag kayong mahihiyang mag-comment down below ng mga, let's say, mga kung may malibaho na sabi, ayaw nyo ba yung way ng pagdidiscuss ko, or kung nagustuhan nyo, sige, paki-compliment, I like that. Okay, so ayan, so don't forget to like the video. It helps, okay, so it helps us push our video through the YouTube algorithm. So magandang bagay yun. So ayan, okay, so coming up next, we will be having the different kinds of obligations. So ayan.